Hey everyone, welcome to my stream. So today we'll be talking about this legal case, which you might have heard of, I guess if you are in Burgerland, and if you're not in Burgerland, you might not have heard of it. Hi Skan Chama, hi Jawa Chama. So this one's kind of in the news, but of course if you read the news, it's gonna be a little opinionated. So I'm just gonna do some shit posting about legal situations, like what's actually going on here, from a legal perspective, rather than a non-legal perspective. So we'll start with my PowerPoint reps. You're a little quiet, I think. Tabun, maybe. Let me check my OBS reps. Is that better? Should be better. Okay. Uh, to the PowerPoint reps. Okay. So basically, we're having this lawsuit, Texas versus Biden, and the background is what's even happening. What is this lawsuit about? So the controversy is started when the federal government ended the MPP, which is short for the Migrant Protection Protocols. The controversial component of the MPP was that the MPP was a policy where certain migrants that arrived and wanted to apply for asylum were made to wait in Mexico while their claim for asylum is evaluated. So this is different from the previous handling where migrants claiming asylum, applying for asylum, were allowed to stay and work in the United States while their claim for asylum was evaluated. So essentially, the previous situation was that any arrivals simply by requesting asylum without having their situation evaluated, were allowed to reside in the United States for an indefinite period of time during, while awaiting the evaluation of their situation. So the MPP was ended earlier this year, I believe, and were sued by the state of Texas and the state of Missouri. And the allegation was two main points. First is the MPP was ended without completing the requirements, satisfying the requirements of the APA, Administrative Procedure Act. That's the first allegation. And the second one is that the ending the MPP in these circumstances caused the federal government to violate the certain section of the Immigration and Nationality Act. So specifically, this allegation is not that the MPP is required to satisfy the requirements of the Immigration and Nationality Act, but it's that under the certain circumstances, by ending the MPP without replacing it with something else, the federal government has begun to violate the Immigration and Nationality Act. So just as a background, who are the people here? So what does all this stuff mean? So this is some background, civics background. If you haven't heard of it, then so basically, what is the role of the executive? So the executive is basically the so-called administration, the so-called government that's doing this. It's a little complicated, but the executive, which is a certain part of the government, is tasked with enforcing and carrying out the law as written by Congress. Congress being another part of the government, and the Congress is given may give the executive the power to make certain laws and regulations, which is known as rulemaking. So essentially, by right, the Congress can write a law that delegates the ability to make more laws to the executive. The executive cannot normally make laws, but if there is a law that says the executive can make laws, then the executive can make laws, and then so in that sense, once the executive is allowed to make regulations, the regulations can make things illegal or not illegal. So for example, you could say the Food and Drug Act gave the power to the executive to make regulations about food and drugs, and then subsequently, the regulations can decide what is and isn't legal, and the federal government can now unilaterally, except for within the confines of rulemaking, make new laws, as many new laws as they want, however they want. Well, not however they want, but they can make new laws, and the voters don't need to be involved in making these new laws, or everyone there making the new laws is unaccountable, essentially. But other than that, basically, the executive is almost completely subservient to Congress. So whatever Congress can think up and write in a law and get passed, then the executive is supposedly has to do it. And if there's a violation of this, violations of the law, if anyone believes that Congress is violating the law, then this can be challenged in court. Okay, so this is just some background about the two things that we're talking about in the allegation. So what is the APA? Well, the APA it does a lot of things, but one thing is like when the government wants to change the rules or essentially write regulations and write laws, they need to do some things such as notice and comment period, write an explanation, and there's a delay from publishing the rules to when they take effect. And there's a whole bunch of stuff in the APA. It's just a huge mess. I'm not going to go into the details of that. And then Section 1225 is the Section 1225 of the Immigration and Nationality Act. It basically has a whole bunch of stuff written in law by Congress about how asylum seekers should be treated. And so essentially these are laws written by Congress. So these laws cannot be changed by the executive. The executive is beholden to exactly these laws as written, but like if it doesn't violate these laws, the executive can potentially write regulations and write more laws relating to this area. So where are we now? So essentially, I put this in the previous presentation, but this is the initial trial. So it goes through restraining order, injunction, dismissal, summary judgment, all these steps. So the original trial, the trial already finished. So it was fast. This thing all happened in only a few months. Normally trials take years. But the reason why this didn't happen is like these appeals, all this stuff in between didn't really happen. These appeals, they just kind of blasted through the trial, went straight to trial and got it done. So this part is done. Now the trial is done and the opinion and order was written. The order being that facts were found already. Wow. Yes, facts were found. The fact finding was completed and the judgment was made. So the judgment was made that the ending of the MPP was illegal. Now, because of this, we're going to the next court now. This is going to appeal. So all of these things can be appealed, but now we're appealing this thing. We're appealing the opinion and order. So what happens now? So we go through the higher level courts. And so the first thing that can happen is a stay. And a stay is where before an appeal, the higher court can temporarily stop the lower court's ruling from going into effect. So if the appeals court, so the district court has ordered that the MPP be resumed, but if the appeals court decides to grant a stay, then the order from the district court is temporarily put on hold while an appeal happens. And then the appeal will look at the facts and the appeal will decide if the decision by the district court was correct or if it needs to be remanded or anything like that, vacated. So where we're going is first we go to the appeals court asking for a stay on the district court's ruling, which was denied. And then next we went to the Supreme Court asking for a stay on the district court's ruling, which was also denied. This was very recent, let's say yesterday, right? So from here, the stay was denied by the Supreme Court. So what happens next? Well, what happens next is we go to the appeal in Court of Appeals, Circuit Court, after which the whole appeals process will begin. So the whole, any questions of law will be evaluated by the appeals court, and it will, of course, take much time to go through this appeal. And then if either party doesn't like the decision from the appeals court, then it can go to another appeal to the Supreme Court. But during all this time, because a stay was not granted, during the time that these appeals are going on, the district court's order is in effect. So while the district court's order is in effect, that means that the MPP must be reinstated. That is the order of the district court. So so when we're asking for a stay, what does it mean to ask for a stay, right? Because the district court has already ruled on this, like has made a decision. The trial is done. So when can the appeals court temporarily put the district court's ruling on hold during the appeals process? So there's a standard for a stay, which is a 4-part standard. The first one being like this is quite similar to the standard for an injunction, but it looks similar, but it's also completely different. So essentially, this was made up by some judge a long time ago, and it's continued. That's the precedent. So applicant needs to make a strong showing that it's likely to succeed on the merits, whether the applicant will be irreparably harmed, and whether other interested parties will be irreparably injured, and with it public interest is. So that's the standard for a stay. And so this one, this is different than an injunction. Where in injunction, all the components must be, you must satisfy all the components, and then the injunction will be granted. But this standard for a stay is that the interests of all 4 of these points will be evaluated by the judge, and the judge will decide if a stay is granted based on these 4 factors. So there's no hard yes or no for any of these 4 factors. Okay, so that's the PowerPoint reps. We can start reading some more PDF reps. Let me do my OBS reps. Where is it? This one. Okay. Let's order. Okay, so let's start with this one. Oops, well, okay, I didn't get the complaint. I meant to get the complaint too, but so this is the order from the district court, and let's read exactly why he found that, why the trial judge found that the APA was violated, and also why he found that the law was violated. So we can skip over this. First, I actually need to show this. There we go. Okay. Saman-chama, welcome to the stream. This might be a boring stream. We're just reading legal documents. I hope you like law. You want to be a lawyer? So there's a whole bunch of chapters. Like first, the procedural background we can just ignore. That's just a whole bunch of boring stuff. Objections. So this is about fact finding, which already happened, which the judge will write about, like which evidence was allowed into the case. So like the defendants made objectives to the plaintiff's exhibits, and the court needs to decide what evidence is true and what evidence is not. So later, like once the evidence is decided by the judge, he'll use that evidence to make his legal decision based on the law. So I think we can skip this fact finding, right? You can see this, like, these are the facts. Out of the found facts, you choose the facts, or is it deciding if it's true or process? Yes. So essentially, the judge, like you don't really choose the facts. All the facts must be taken into account. The judge can decide, like, if there's a dispute between which facts are true. Like if facts are disputed, then the judge needs to decide. You can see here that where is it? So here it says court consolidated the hearing. Proper standard for factual findings is the preponderance of evidence. So preponderance of evidence is a legal definition where a certain amount of evidence is required for a fact to be considered true. So you can say like preponderance of evidence. Something else would be like beyond a reasonable doubt, for example. So all of these bullet points are facts that were determined. And earlier in the trial, like each side submitted documents and other evidence that supported the facts that they wanted to use. So just like, here's one example. Like, I don't think we want to read the examples of the facts, right? Like, one fact was just MPP was created to combat an influx of illegal aliens during the Trump administration. So this is just one fact that was made. Yes, resolving disputes with the fact in a consistent manner. That's correct. So like, there's just an example of a fact. In 2018, the United States experienced an immigration surge and a resulting border insecurity crisis. So this is a fact. And this fact will now, it was decided, this fact was accepted by the judge, and now it will be used later in the decision. Now, let's go to the actual questions of law. I think like fact finding is not that interesting. It's just facts. It's the questions of law that are more interesting. So we go to conclusions of law. So plaintiff has standing. So of course, if you saw the previous stream, you know that for someone to sue in a lawsuit, you need to have standing. So the plaintiff needs to have a standing to do a lawsuit. So the plaintiff needs to be harmed by the action of the defendant, and needs to be under the jurisdiction of the court. Those are the main things. So here we say state needs to show an injury of fact. This is not that interesting. So basically, they've shown they are going to be injured by the termination of the MPP. This is not that interesting. That's not really disputed. And jurisdiction means that, so this jurisdiction is a little bit disputed, but not really. I think we can just skip that too. Let's skip straight to the questions of violation of APA. So here, termination of MPP violated APA. So this is the first, like, of the two main points, these are the two main allegations that were made by the plaintiffs. First, termination of MPP violated APA, and second is the termination of MPP caused the violation of Immigration and Nationality Act. So basically, we'll go into the details. APA prohibits agency actions that are arbitrary, capricious, abuse of discretion, or not in accordance with the law. So they require reasoned decision making. So, well, it's a little sketchy saying this, but due to the APA is just a whole bunch of red tape, I guess, before the agency, which is the federal government's agency, can change the law. So agency must examine relevant data and have a rational connection between facts and the choices made. So we go down here and say that it's about the rationality of how the agency made the decision. So we go into some points. So these are like small details, kind of annoying, but so the agency's action of terminating the MPP did not consider all the relevant factors. And so, for example, the government failed to consider the benefits of MPP. So by terminating the MPP without considering its benefits, the government has violated the APA. So this can easily be gone around. Basically the government simply needs to consider the benefits. So if the government did write and provide evidence, they considered the benefits of MPP, and then found somehow through logic that the detriment of MPP was greater than the benefits of MPP, then they would be able to legally satisfy this hurdle. But due to the fact here it says the June 1st memorandum never once mentions these benefits. So essentially, the government's explanation for why MPP was terminated did not explain why the benefits were outweighed by the harm of MPP. So because they did not consider that in their decision making, they did not satisfy the requirements of the APA. Yes, I see they didn't say anything. So, and then of course, like it was the federal government that made MPP in the first place, and by ignoring its own assessment of why MPP was good, then of course they acted arbitrarily and capriciously. So essentially, all this is basically saying they didn't explain themselves well enough, so they can strike this law down. Of course, this is really a little bit bullshit, but essentially, like when enough of these cases happen, the government needs to kind of learn all the cover your ass moves and rubber stamps to get before they can actually make a change. And then once they like tick off all these boxes on all the things that they have to satisfy for APA, and they do it right, then they can get past this hurdle. So this is violation of APA, and then of course it's all red tape. So they did all these things wrong. And then of course the next part is violations of Section 1225 of the Immigration and Nationality Act. So here he goes over the actual component of this. So alien subject to removal does not have so this is law written by Congress. So because of that, the administration, the executive government must follow this law. This law is already essentially set in stone to the federal government. They have no, they just have to follow it. So to them, this is set in stone. Of course, Congress can change it, but that's not happening anytime soon. So what this law says is after this determination determines that this alien does not have credible fear of persecution, the alien shall be detained pending final determination, and if found not to have such a fear, until removed. So this is essentially what the government has to do. And so this is a little bullshit in a sense that, like, the termination of MPP caused the defendants to violate this section. And of course, so that doesn't mean the MPP has to be reinstated, but it does mean that the MPP can't be terminated until the government can terminate it without violating Section 1225. So here, this part shall be detained is set in stone, so the administration cannot is not allowed to violate this. Anything the administration does that causes this to be violated is illegal, essentially. So all these sections shall be detained. So specifically, it doesn't mean that MPP has to be followed, but it means that under the circumstances of how the government terminated MPP, it caused the government to violate Section 1225. So let's go now to what the plaintiffs got. So what did the court decide in the end? So here's the remedy. So the court has to, of course, provide relief. So APA violation shall hold unlawful the agency's change. And so this is pretty complicated. This is a whole bunch of legalese. So ordered. The June 1st memorandum, which is the memorandum that ended MPP, is permanently enjoined and restrained. So that doesn't mean that MPP has to exist forever, but it means that the July 1st memorandum, which ended MPP, cannot happen. So if there's a new memorandum that's different, then MPP can be ended, potentially. And defendants are ordered to enforce and implement MPP in good faith. So MPP must be reinforced until it is rescinded in compliance with APA. So if there's another memorandum that complies with APA, and until such a time that it can be that Section 1225 can be complied with while also ending MPP. So of course these are that's the order. So this is the order that the trial court happened. This is the result of the trial. So, of course, now we go here. So when we're here, this is the district court's order, and the government is not happy with that. So the government is going to ask for a stay, saying that the government wants to appeal. The appeal is going to take a long time, so they want a stay while that appeal happens. So the stay will put the order on hold until the appeal is finished. So we can go to what did the Court of Appeals say about giving a stay? So this is a Court of Appeals for the Fifth Circuit, and what are they saying? So the full trial happened, and of course, if you want to read these documents, well, I guess you can just, I'll post these documents in the video description later, so you can read the whole document. So DHS seeks a stay pending appeal, and they did not. The Court of Appeals found that they failed to satisfy the 4 factors. So we can. So this is just background. We don't need to know it's background. So there's the 4 factors, and then they will address these 4 factors one at a time. Government needs to make a strong showing is likely to succeed on the merits. Whether the government will be irreparably injured, whether other interested parties will be irreparably injured, and whether the public interest lies. So first part is, well, so the government will argue yes on all 4 of these. Yes, that the government thinks that is a likelihood of success. The government will argue that it would be irreparably injured. Government will argue that other parties will not be irreparably injured, and of course, government will argue that its position is in the public interest. But these judges will here are deciding that's not the case. Now, so in this case, government argues it's likely to succeed because of standing and non-reviewability. So this is pretty interesting. This is not actually about whether or not it violated the APA, but is arguing that states don't have standing, and arguing that this change is not a decision that can be appealed under the APA, or not appealed, cannot be reviewed by judges under the APA. This is kind of boring. And so, and then the second one, like argue that the decision is unreviewable. And the next argument is, of course, this is not actually a rulemaking. This is actually a non-enforcement policy. But non-enforcement policy it's not the case. So a little bit, I don't know if I should derail on, well, not really derail. Talking about non-enforcement policy. So enforcement policy is that the government is not required to always enforce the law. There's a certain discretion. For example, the government could let criminals go if they want. That's not illegal for the government to let criminals go. They can just let them go. And that's just discretion. They say, like, if someone's committing a crime in front of a cop, you can just say, I don't want to. I don't want to intercede. So in this case, the government doesn't. So this is the non-enforcement decision, the claim that they can just not do anything. But this is not a non-enforcement decision because it requires a whole bunch of things. Like it requires the government to actively release and parole these aliens and place them in the United States and create affirmative benefits. So it will be granting these people work authorization. So this is not just merely not enforcing a law, not merely ignoring a crime, but is also affirmatively giving these people work authorization. So because of that, this cannot be considered a non-enforcement decision because the government is essentially creating rules that allow certain people to get a work authorization. So we can go through all this. This is essentially saying, like, rehashing all the stuff we saw previously, but kind of briefly. Well, it's supposed to be brief because this is just it's not an actual trial on the facts, but of course, it ends up that a lot of evaluations of this question, strong showing of likeliness of success, it's quite close to an actual evaluation of the questions on law. But it's not exactly the same. How it's different is kind of very subtle. I'm not going to go into the detail just yet. So, and then the second part is violation of Section 1225. So the government claims district court determined this, and that this is not correct. Well, this is a little complicated legalese, but essentially he's just saying what the district court said is correct. Sorry, not a very good explanation for me. So no showing of irreparable injury absent a stay. So the government will not be irreparably harmed. How could the government be irreparably harmed? Basically just going to say that. And then final two factors. Other parties, so we say the other parties, the states, interested parties, will suffer harms and irreparable harms. So the appeals court agrees on that. And then public interest. So the public interest is in the government following the law of the APA and Section 1225. So because of that, of course, says this is not the public interest. And that's it. So it is denied. We can go to the next. The Supreme Court is actually much more brief. The Supreme Court is usually too lazy to get into these little fine details. So we look at what the Supreme Court says, and they simply say, this is not a denial of the appeal. This is a denial of, so let's go back to, I tried to show my PowerPoint, but I didn't, needed my PowerPoint reps. Where is PowerPoint reps? So where we are here is district court trial is finished, and we haven't even gotten to appeal yet. They're just asking for a stay pending appeal. So the stay will only put the order on hold until the appeal is finished. So they asked the Court of Appeals for a stay until the appeal happens, and then they asked the Supreme Court for a stay until the appeal happened. And yes, we're still in the stay section. The appeal happens next in the future. So the Supreme Court went very briefly. So they just went and said, the applicants have failed to show a likelihood of success on the claim that it was not arbitrary and capricious. And that's it. The Supreme Court doesn't have time to go into the details. They just say, well, they didn't satisfy checkbox 1, so we're done. I see. Basically saying the lower court was right. No, they're actually not saying the lower court was right. They're saying, well, they're saying that they haven't. They're saying that the people asking for a stay, the government, they're saying the government has not shown a high likelihood of proving that the lower court was wrong. So this doesn't affirm the lower court's ruling. They haven't actually looked at the lower court's ruling. They just looked at the argument that the lower court was wrong. Yes, basically saying the appeal asking for a stay did a poor job. That's it. Essentially, that's it. They say they failed to show a likelihood of success. Essentially, the appeal was weak appeal, go away, weak appeal away. And that means that there's no stay. Now, we still get to go. Like, we're still gonna go to an appeal, because they get an appeal anyways. They have the right to an appeal. The government has the right to an appeal. Anyone suing has the right to get the appeal. So they're gonna get their appeal, but they just don't get a stay. They don't get to put the district court's the result of the trial on hold while that appeal happens. They think the appeal is going to lose, but who knows? Like, anything can happen. Yes, that's correct. We're on to real appeals now, but in the meantime, their memo is rescinded. Okay, so this is real legal documents, and now we're going to go past legal documents, and we're going to look at the shitposts. So these are not legal documents. These are merely documents written by other people, and these are people who disagree with the ruling. So let's look at the first one. These are going to be shitposts, and remember, these don't have any legal weight. These are just opinions. So first, we can look at the New York Times. So these are people disagreeing with the way things have gone. They believe that things should have gone differently, and we can read why they believe so. But of course, it doesn't mean anything. So here, the judge claimed that. Of course, we went over this. The ruling is that the termination of MPP caused a violation of Section 1225. And this guy claims this is a novel reading of the law. This view had never been accepted by any presidential administration. But if we look, so we look at what this says. Novel view. Novel. Huh. Never been accepted. Worse yet, the court's injunction derived. So this is a legal document, but it's not written by a judge. It's written by a lawyer. This is argument of the lawyer. He claims court's injunction derived from its extraordinary conclusion that Section 1225 leaves the government with only two options: detention or return to a contiguous territory. And he claims this has never been accepted by any administration, which doesn't matter. This is not something that was ever in court. Like what an administration thinks the law is has no effect on what the law actually is. What the law actually is decided by judges. So this doesn't matter. Who cares? Who cares what the previous administration thought? We care what judges thought. This is one thing I didn't talk about. Administration doesn't set. The administration doesn't set precedent. So we could say potentially, maybe. Well, of course, we haven't said that for sure, but maybe every single administration since 1996 has been violating Section 1225. That could be possible. Just no one sued. It could be, and well, we don't know. So this is something I didn't mention in the procedural. So this is one thing. A judge can suspend his ruling during this request for stays. So this is kind of a courtesy. So the original judge says, "I will leave my ruling for a week while you ask for a stay." So here, while asking for a stay, while this stuff happens, the ruling is just put on hold for a week. And this is the original judge just doing it as a courtesy. The judge doesn't have to do it. But if the judge doesn't do it, there's a chance that a stay takes time to get. And there's a chance that the higher court will give like an emergency order. Like before a stay can happen, they'll put the thing on hold. Like an even shorter hold. Like, I don't know the name for it, but like the higher court can put it on hold before the stay happens. And the judge doesn't want that, so the judge usually gives the courtesy. You don't really want to challenge the higher courts. Let them have their time. So yes, and then of course so this is what happened. So this stay, the first judge put his ruling on hold for a week while the government asks for stays. And actually, this is what happened: is that this on hold for a week wasn't enough. So the higher court, the Supreme Court, actually basically did their own, like, put it on hold. We're going to put it on hold until we can actually evaluate a stay. So this is partially why, like, the lower court does this courtesy, is because if they don't do this courtesy, the higher court is likely to put the ruling on hold themselves while they consider whether or not to grant a stay. But of course, this is something that is always a matter of weeks at most. So of course, this is another person saying that the MPP is actually illegal, which of course maybe it is, maybe it isn't, but well, it takes another lawsuit to claim the MPP is illegal. If you claim the MPP is illegal, then you should go to court and have the court agree with you. If the court doesn't agree that the MPP is legal, then it's not illegal. And another claim that opponents of this is that the court's ruling dictates foreign policy. That's something is certainly a belief that some people have. Oh, do we run out of New York Times? Anyways, so those are some opinions from some opponents of this belief. And let's go to the next one, the more shitposty one. New York Times is, of course, shitposty, but we're going to go even more shitposty. This Supreme Court case could blow up decades of diplomacy. So this one, of course, the author actually is going directly into what he believes. He says the opinion is wrong for many reasons, including that he misread this law. He didn't. They're going hard. Wow. Yes, of course. So whenever a ruling happens, like, everyone's going to come out of the woodwork on the side that lost and, like, go really hard with rats. These are essentially all rats. This is rat, because, well, these are all rats. This is we're reading rats. So, So, of course, this guy said intended his order to take effect on Friday, given just 1 week to reinstate the policy. This is actually not the case, which the appeals court went into. The appeals court said that the order takes effect, and that time to take effect is just to give time to ask for a stay. The policy does not need to be resumed completely, fully overnight, but it merely needs to be in good faith to a resumption of the program. And that's the order from the district court judge. So this guy is kind of going hard. And of course, extended the deadline so the court can consider. Because the original deadline was so the court can just consider, and this was extended a little more. So of course, this guy is saying these are the stakes of the case, but in the end, like, we shouldn't be talking about the stakes of the case. The stakes should be upholding the law, the correct law of, like, what does the law say? What did Congress pass? And, like, are we going to have a government that that follows its own word? That's the real stakes, right? The court should be deciding based on the law and not based on, the court is a legal instrument, not a lawmaking instrument, because of an egregious misreading of federal law. Well, if it really was an egregious misreading, then of course the Supreme Court would not let that stand. Or any of the above courts would not let that stand. And this is just some background. So one thing this guy says here that is interesting is that he claims that the states should not get where is it? Don't get involved with foreign relations, and Heinz. Court explains Heinz. I'm not really explaining this article very well, am I? So, let me see what he's saying. So, what this guy claims about Heinz is that Heinz, the state cannot impose a treatment on foreign nationals. So, the author of this article believes that Heinz is relevant. Heinz being a case that says the states cannot impose treatments on foreign nationals. But the state's involvement in this case is actually completely different because the state is really it's anyone harmed, any party harmed by the violation of the law can go to the court, and they're only asking the court to enforce the law, to make the federal government follow its own law. So essentially, this is not the states interfering with policy. It's merely asking, the states are merely asking the court to enforce the law as written. Like saying they're doing this, but that's illegal. Yes, essentially. So you just go to the court and say they're doing this, but that's illegal. And even if you shouldn't get involved, so-called, well, all you're doing is saying they're doing this, but that's illegal, and then the court can take it however they want. The court can fix it and say, yes, it is illegal. This is a legal decision. So here they say, Texas litigation is an attempt to bypass the Supreme Court's warning that federal officials, not state governments, get to decide our nation's immigration policy. This is not correct because the state government is not deciding anything. The state government is merely going to the court and saying, they're doing this, but that's illegal. Anyone can do that. Anyone. And of course he says this decision was dead wrong. Dead wrong. And well, if you go into this guy's just going to restate the government's case, in which of course the judge's decision will of course knock down all these points. So essentially reading something like this is really worthless because everything he says was already rebutted by the decision, by the judge. The judge already went over all these arguments and said they're wrong. Yeah, I'm not actually going to read this. So see, this guy's bringing up prosecutorial discretion, but we already looked at this PDF over here. And he's the judges were very clear. Where is the discretion? It's somewhere here. Under C. No, not C. Is this is the Court of Appeals? Yeah, it's Court of Appeals. E. So this guy is he already knows this exists, and the judge was very clear in writing here that where am I looking at the wrong part? I think I'm looking at the wrong part. Well, you could look at I Wait, is it here? Oh no, he's talking about it's under unjustifiability. So, sorry, I'm being silly. Omissions, legal implications, alternatives. This is Court of Appeals, right? Or should I be looking at the other one? A. It's not A. It's B and yeah. Okay, here. So here, under C, page 17. So the judge was very clear. The government argued that MPP was only a non-enforcement decision. So non-enforcement decision being prosecutorial discretion, similar doctrine. So the judge was very clear in this argument where he laid out this whole legal analysis that this is not a non-enforcement decision. This argument fails, and this is not a non-enforcement decision. Clearly here. And of course, this guy, going hard, writes an article completely ignoring the fact that he writes an article about this judge's ruling and says, oh, but prosecutorial discretion exists, so this ruling is wrong. But how can that be? The judge explicitly and clearly addressed this point. So these are just these guys with their opinions with these rats. These are dead rats. Yeah, the dead rats keep coming. Anyways, I'm gonna stop now. The dead rats keep coming. Anyways, so I think that's enough. This is going to be a short stream, so we are pretty much done. That's all I wanted to talk about. Probably have another legal review later. And the next stream, Puyo Puyo, I don't know if Puyo Puyo is actually going to happen. I'll try to make it happen. If not, then we won't have Puyo Puyo. Yeah, Jao Chama. Thanks for coming. So, thanks for coming to the stream, everyone. And I will see you all later.